Hello guys, welcome to LawPutra YouTube channel, and our today's topic is delegated legislation and conditional legislation. We all know that we have the three arms of administration: how we administer the law, how we enforce the law in any country. The first and foremost and the most important is the arm, that is the legislative arm, which in fact actually enacts the law. Then the legislative involves both in a country like ours, which is a federal state, central as well as state. Central legislature, that is parliament, and state legislature, that is either the legislative assemblies and legislative councils. The second arm of administration is the executive arm, which looks after the enforcement of those enactments, those laws. And the third is the judiciary, which interprets the law and which keeps check on the enforcement and as well as the implementation as well as the interpretation of the law. Now let us see what is meant by legislation. The word legislation has made up of the two Latin words legis, which means law, and latum, which means to make or to set. So legislation is nothing but the making of law. That source of law which consists in the declaration of legal rules by the competent authority. It includes all methods of lawmaking. It includes process of lawmaking and law evolved as a result of this process. So this is the legislation. Now, why legislation is the most effective source of law in the jurisprudence? Number one is that it involves the laying down of legal rules by the legislature which the state recognizes as law. And secondly, it has the force and authority of the state. Now, when we talk about the delegated legislation, the word is very important, delegated. Legislation and the power of legislation is being delegated. Legislation by executive, and by the word executive, we mean any authority which is other than the legislature. And when such authority which is other than the legislature legislates, it becomes the delegated legislation. So it is a sort of subordinate legislation. And to enforce the law, as we know, is the main function of executive. But for regulation of its own departments, the power of rule making is delegated to this executive. And rules, orders, notifications, bylaws, directions, that all are combined in this delegated legislation. Now, delegated legislation is, as we have seen, it is the exercise of power of rule making by executive, which is under the authority which is delegated to it by the legislature. And it is the output of that exercise of the power of rule making. When we say the delegated legislation, we can see the enormous increase in India. And at the moment, it even outnumbered the legislative enactments. The first reason is that the welfare state, because of the tremendous increase in work of government, the huge bulk of legislation, and parliament to define only essential legislative principle and practice to be delegated to executive arm. This is the first reason. Second is the lack of adequate technical knowledge about certain subjects. Then to avoid some unforeseen contingencies, the power of constant adaptation to unknown conditions without necessity of amending the original legislation. Then we can see the third reason, that it is necessary to meet the cases of emergency which are arising out of, say, war, insurrection, floods, economic depression, epidemics, etc., where executive needs to be armed with rule-making power for appropriate remedial action. And it is immediately, without waiting for law passing, which is the lengthy process, as we all know. The fourth reason is that the certain specific areas such as rationing schemes, imposition of export duties, import duties, then exchange regulations, etc., law should not become public till it finally comes into operation. And we need to maintain the confidentiality which is in the public interest itself, Therefore, legislation prefers this delegation. The fifth reason we can see that the members of legislature, they may be seasoned politicians, but they may be lacking expertise and adequate knowledge of highly technical matters such as nuclear energy, electricity, gas, atomic energy, etc. And then it will be difficult for the parliament to lay down the details in some technical fields. And that's why it entrusts these things to the executive, which is supposed to be well versed in these technical fields. And complexities of modern public administration and expanding dimensions of socio-economic function of the state necessitated the delegation of legislative power to enable the executive to devise these new forms of law for effective realization of goal, that is economic justice and implementation of welfare schemes of the state. Now let us see what is meant by conditional legislation. Legislature empowers the executive to, number one, extend the operation of an existing law to any particular area or territory. It also empowers to determine the time of application of an act to any given area. It empowers to extend the duration of a temporary act subject to maximum period fixed by the legislature. Fourth, it also empowers to determine the extent and limit within which it should be operative. And fifth is to introduce any special law if the contemplated situation arisen in the opinion of the government. So these are the 5 empowerments by which this conditional legislation emerges. Now let us see the distinction between these two, delegated legislation and conditional legislation. The first is, in case of delegated legislation, it is the conferment of lawmaking power upon some other body. And in case of conditional legislation, the legislature itself enacts the law and give to some other body only the power of determining when it should come into force or when it should be applied to a particular area or territory of the state. No delegation of legislative power. These are the only conditions. So in first case it is the conferment, in the second case it is the enactment. Second distinction we can see is the power of legislation is transferred or delegated in case of delegated legislation. But in case of conditional legislation, such power of legislation is not transferred or delegated. We can see one more distinction in these two, that is, delegated legislation involves delegation of rule making power. To whom? To administrative agent. And what happens is the legislature, after having laid down the broad principles of its policy in the legislation, can leave the details to be supplied by the administrative authority. And in case of conditional legislation, we can see that the delegate's power is that of determining when a legislative declared rule of conduct shall be effective. So this is the basic difference between delegated legislation and conditional legislation. Now let us see some case laws. The first and foremost case laws in the year 1927, it's a US case, Hampton and Company versus United States, in which it is mentioned, the court held, delegated legislation involves delegation of rule-making power which constitutionally may be exercised by the administrative agent, and conditional legislation involves delegated power of determining when a legislative declared rule of conduct shall become effective. Let us see one Indian case, which is the Hamdard Davakhana versus Union of India. It is the 1960s case, and Supreme Court held that delegated legislation involves delegation of rule making power which constitutionally may be exercised by the administrative agent. And this is one more case. Again, it's a US case of 1982, which is Field and Company versus Clark. It says that to assert that a law is less than a law because it is made to depend upon a future event or future act to rob the legislature of the power to act wisely for the public welfare, whenever a law is passed relating to a state of affairs not yet developed or the things future and impossible to fully known. So this is the very crystal clear it is mentioned in this case. So with this we come to the end of this today's topic, delegated legislation and conditional legislation. Thank you.